அப்ப
ക്ലാസ് എടുക്കാൻ തുടങ്ങിയിട്ടില്ല. കേൾക്കുന്നില്ലല്ലോ.
Kindly ensure everybody is muted because it is too much interrupting while taking the sessions for the lecturer. So kindly make sure that your mic is muted.
Good evening, all.
Good evening,
So we
ma'am.
are. Yeah,
Good evening.
yes, yes. Yes. So we are, like the last last session of business law. So as for the last two sessions, we have now like seen about what is business law, and what are the types of, like how to come to like an agreement or a contract. So what are the basic necessity needs, and how these laws, it can be, acknowledged by law, that is by the government and the law. So if at all it is enforced under certain rules and principles. That is, if it is not just an agreement, few agreements can be voidable, and only when an agreement becomes a contract, that is enforceable by law. But an agreement, just as an agreement, it cannot be enforced by law. So an agreement cannot be contract always, but on the other side, a contract is always an agreement, a legal agreement between two parties. Either it can be two business individuals, or it can be between a business individual and a business entity, or between two business entities. So, as a final session, we are going to see about, other than we have Indian contract law, we have no mercantile law. So we are going to see about few more laws. So with that, we will be almost completing or covering almost all the laws which is mentioned in the business law module. So let's start with the characteristics of law. So what are the characteristics? So a law means it has a body of rules, and it is for the guidance and conduct of persons. It is how the persons has to behave, or exert a business relationship, or an ethical behavior in the business world. So that will be a guidance. So what procedures to be followed, what things has to be taken into consideration. So the law is enacted for the guidance and conduct of persons. It should be imposed. The laws, it has to be, it should be imposed. This is not something which is just written in general, and it's for the the public or for business personnel, but it has to be imposed. Enforced by the executive, presupposes a state, contents are non-static, that is it should be always dynamic. Develop social order and compel social member to remain in order. Serves social, political, economic purpose, and it should serve law and morality. So that is what being translated into Greek, which is ignorantia juris non executat. It is law, maintaining law and morality. So there are many classifications in law. As of now, we have seen about what is all the the Indian contract law, and we have seen about the mercantile law. Now, coming to the general classification of law, we have public law and private law. Public law, it protects the public. That is, it protects the general public, and private law, it protects the private, individual persons or some private firms. We have criminal law and civil law, and criminal law is for any criminal offense, exerted against any person or against a government. And civil law, it completely takes care of all the the domestic attributes and everything. You have substantive law and procedural law, then international law and municipal law, and public international law and private international law. So public international law is, except encovers the general public, everywhere in the world. Whereas private international law, okay guys, please mute your audio. Private international law is something which protects the rights, and which protects the the legal affirmations of the private firms, that is the individual firms or individual persons in international domain. So revocation or lapse of offer, when does a lapse of offer happens, and how can it be revocated? So it can be either by communication, or in case of death of insanity of either party before the acceptance is made. So in that case, the offer becomes a lapsed one. If an offer becomes lapsed one, it means that there is no consideration happening. So if there is no consideration, obviously there is no acceptance happening. And if there is no acceptance, then there is no agreement. So in case of the death of any of the either parties, no, like it becomes a lapsed one. By lapse of time, if not accepted within the prescribed time, an offer becomes a lapsed one. Non-fulfillment of specific condition. If a specific condition which is mentioned in the business offer, if it is not fulfilled, then no, like it is nullified or it is no like lapsed. If a counter offer is made, so what is a counter offer? So something which is not mentioned in the offer, but a kind of an offer which is made, like over the table in the sense when no, like when offer is made, that is, it is not in words. It is not in no like a written format, but it is only in the words. So that is counter offer. Something which is no like some change has happened or no some change has been no like mentioned when the business talk is happening, but that is not mentioned in the offer. So that counter offer is made, then there is a lapse of offer. If the acceptance is not according to the prescribed mode and the offeree is informed. So if it is not in the prescribed mode, then no, there is a lapse in the offer. And revocation and rejection. If no revocation or rejection no like happens or it is being made by either of the party, then there is a lapse in the offer. So legality of object. So section 23 of business law, no, like it declares that object and consideration of a contract should be lawful. So what are all the points which is mentioned under this section is consideration and object could be unlawful if it is forbidden by law and if it is such a nature that if permitted, it would defeat the provisions of law. That is, if it is being executed, so the after effects of this execution may disturb the other laws, may make the other laws which has already been endoctrined, no, like to get nullified. So in that case, this law cannot be enacted. If it is fraudulent, if it involves or implies injury to the person or property of other, and if the court regards it as immoral, like everything is fine, even though if it is following the exact business law procedures and everything. But finally, when the court says no, that is an immoral act, then obviously you have to know, like ban that object. And if the agreement is opposed to public policy, anything which disturbs the public, which is against any kind of public policy, so in that case, the legality of the object would be unlawful. So contingent contracts. Guys, please mute your audio. Okay, thank you. So contingent contracts may be absolute or contingent. So let's see what is absolute contract. So it is one in which the promiser binds himself to performance in any event unconditionally. Unconditionally in the sense, no, like everything, no, the promiser, no, like does or no, like takes the responsibility of completely taking care of the business procedures. So there is no such thing called no, like a contract is happening. Even if it is a contract, it is a contingent contract. That is the promiser, whoever is now promising the business offer, or they are no like ready to take any kind of responsibility, no, which is happening in that business or the trade. But whereas a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. So contingent is something no which is to do or not to do. That is clearly mentioned here. Absolute contract is something which is no like the promiser does everything unconditionally. Any event in the business transaction, so everything is accepted by the no the promiser unconditionally. Whereas contingent contract is something where no the clearly everything is mentioned. So three essential characteristics of contingent contract. The first essential character is its performance depends on happening or non-happening if some event in the future. So it depends upon no everything which is going to happen in the future. So if some future event is going to happen, then this business procedure will go on. Or if the future event, no, which is speculated is not happening, then this contract becomes a void one. So in that way, in that no like context, the contract is made. And second point is the event must be uncertain event. It should be no like it should be something uncertain. The third one is the event must be collateral, that is incidental to the contract. So if these three characteristics no like if it is applied, then that becomes a contingent contract. So next we have is discharge of contract. So it means the termination of the contractual relationship between the parties. So when does the contract become, it can be terminated. So a contract may be discharged by the performance of the parties. If they are not, abiding the the guidelines, whichever is mentioned in the contract. So the performance is not happening according to the guidelines. Yes, it can be discharged. That is, it can be terminated. Agreement of consent, that is not happening. Yes, there is no like by force or by no under any such unethical condition or consideration. If either of the parties is forced to enter into a contract, so in that case, yes, this can be terminated. Impossibility, lapse of time, operation of law, and breach of contract. So for any reason, discharge of contract, which is the termination of contract, can happen. So there are remedies for breach of contract. So remedy is something no, which can be given by law for the enforcement of the right. So when there is a break of contract, the injured party has one or more of the following remedy. The injured party in the sense who has suffered a loss. Here in the no, like it means no, in business context, who has suffered a business loss. So rescission of contract, suit for damages. So this since it is a contract, no, they can directly approach the law. Suit upon quantum merit and suit for specific performance of the contract and suit for injunction. For any of these reasons, the contract can be made as a valid document for approaching the law and taking necessary actions to make sure the party who has suffered a loss because of because of various reasons that loss can be justified. Contracts of indemnity and guarantee. So these are no few sections. I don't want to get into deep into this because sometimes it may be confusing for you. So all we have mentioned here is the Indian contract law and whatever it has covered. So there is a promisor, that is there is a promisee, and in between them there is an indemnifier, and there is an indemnity holder, which is a a person or or an entity which is affirmed by the law, indemnity holder. The rights of indemnity holder when sued, it comes under section 125, and rights of the indemnity, the act is a silent act. So here the indemnifier, that person or that particular firm or an agency or an entity acts as a mediator between the promisor and the promised. And then is the guarantee. So what is a guarantee? A contract of guarantee is to perform the promisor or the discharge of liability of a third person in case of his default. So the person who gives, so that is who submits everything to make the off to to accept the offer. That is called as surety. Who defaults is called the principal debtor, and to whom it is given, it is they are called as a creditor. So it may be in oral or written, or no, it is expressed or implied. And few essential features are concurrence, that is primary and secondary liability. And there is an essentials of a valid contract in case of principal debtor. Who is the principal debtor here? Who has defaulted? Being a minor, the surety is regarded as a principal debtor. In case, if at all no, the debtor in the principal debtor is a minor, then the surety is regarded as a principal debtor. So who is the surety here? The person who has given. So it means indirectly this says the surety cannot be given to a person who is not a major. I mean, who is not a major. Shouldn't be given to a person who is not a major. So any business contract law, to get into the contract or get into the business contract, the transaction or whatever it is, So any person or no, like any company, especially any individual, they have to be a major to get into the contract. You cannot make a contract with any of the minors. Then is the pledge. So bailment of goods as security for payment for a debt for performance of a promise is called a pledge. Pledge is nothing but a kind of a surety. So you're not like giving a surety kind of a thing to know like to the promising that the payment would be done later on. So the bailer is called the pledge or pawner and the bailee is called the pledge or pawnee. So whoever has no like bailed it, so that person is called the pawner and the bailee, whoever has accepted it, that no, that person is called as the pawnee. Pledge is bailment of goods as security. Bailment is for a purpose of any kind. In case of default, then what this pawnee does is they may sell the pledged goods and bailee may either retain the goods or sue for the charges. So either they can no like sell the goods or no sell the pledged, like whatever is being pledged, so that can be sold, or no they can retain that no pledged that thing or the document or the, like asset, whatever it is, and sue for the charges. In case of pledge, the pawnee cannot use the goods pledged. That is, in case of pledge, the pawnee cannot use the goods pledged. In case bailment, bailee may do so if the contract so provides. In case of bailment, if the bailment has been done, then in that case, the bailee can no like make use of those goods. So till the pledges no like it's under no the provision, the pawnee cannot make use of the goods. But in case of no the debt has happened and no like the whoever has no like made the pledge or no like gave the surety, they have no like bankrupted or no like they have no like have a dissolvency problem. So whatever reason is in that case, then the bailee can no make use of the goods. And note here, the bailee and the pawnee is called like they are one and the same. They are not different persons. Then is contract of agency. So this comes under section 182 to 238 of Indian Contract Act. So an agent is a person, uh, especially not a person. It can be an individual, it can be a business firm, or it can be an agency employed to do any act for another or to represent another in dealings with third person. So person who represents is called the agent and the person who was represented is called the principal. So what are all the essentials of agency relationship? So agreement between the principal and the agent. So there should be an agreement happening between the principal and the agent. That is the person who was represented and the person who represents. And no consideration is necessary to create an agency. And the second point is intention of the agent to act on behalf of the principal. That is no like there is a power of attorney that is being given to the agent to act on behalf of the principal, that is who has no like represented. So in that case, agent no like holds more like power there, because agent gives a power to this. Sorry, the principal gives power to this no like an agent who's going to act on behalf of the company or behalf of that person. So the agent can no like to take business decisions, sometimes with the consideration of the principal or sometimes without the consideration or consent of the principal. The agent can take decisions. But again, that has to be mentioned in the contract. So if at all in the contract, if this point is not mentioned, then an agent taking decisions without informing the principal person, so that is not like completely offensive. It can be no like considered as a criminal offense, and no like the agent can be sent to jail, or no like if an agent is a company or no, it can be sued actually. Only if the party has mentioned that in the contract, then the agent can act as a power of attorney for the principal. If it is not mentioned in the contract, an agent has no right to act on behalf of the principal. And then comes the Sale of Goods Act, so which was now like enacted in 1930. So this comes under Indian Contract Act. So sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. The first thing is confirmation of the goods, and the second thing is confirmation of the price. And the third point here is from where the goods ought to be collected and where the goods should be delivered. Sometimes the seller may take no responsibility at all, no, in selling, I mean, in no like transportation and delivery of the goods. The buyer takes all responsibility of collecting the goods from the seller's place. And or sometimes, no, like sometimes in the sense, no, like everything, it's all these terms and conditions is based upon the business relationship between the seller and the buyer. So sometimes the seller will agree to pay for the transportation of goods to the nearest port or to the nearest location, or sometimes to the seller's place itself, whether it's a no like a house or a no like a warehouse or no to a production house, whatever it is. So the seller agrees to pay for the takes care of the transportation of the goods. But all the other things, no, like that would be bared by the buyer. That is no like taking care of the documentation charges, insurance charges. So that will be taken care by the buyer. And the third point, another no like there is no like there is another a situation where the seller takes completely all the responsibility of taking insurance for the goods and no like taking care of the transportation cost, taking care of the packing, packaging cost, and taking care of the delivery cost. Everything from A to Z, the seller takes all the responsibility. And the buyer does the buyer doesn't have no like much responsibility other than paying for the goods once the goods has been delivered, or sometimes no, the money can be no like paid as an advance to the seller. So these things would be mentioned in the contract. So these agreements, no, like these terms and conditions, no, which comes under Incoterms in no like shipping or no sale of goods. So that would be clearly mentioned in the contract. So it says which responsibility is on which party, whether the seller is going to take this responsibility or the buyer is going to take care of this responsibility. Responsibility is nothing but the payment for a particular activity. So payment here, no, like you have to pay for everything when the sale is happening. So first, the payment has to be done for the goods which is to be sold, and that is done by the buyer. And second is no like transportation charges. You have to pay for the transportation. You have to pay for the labor charges. If at all the goods has to be no like handled and placed on the transportation truck. So in that case, the labor charges has to be taken care of. And the fourth point is if it is an international shipment, in that case, the products, the goods goes by either air mode of transportation or sea mode of transportation. So in that case, port handling charges. So that has to be taken care of. And then you have custom charges, the custom duty charges. So that involves no like yes, that is has to be taken care of. Then the carrier charges. That is whichever carrier is no like responsible for transporting the goods from to international locations. If it is no like air mode, there are commercial airplanes which no like transports the goods. You have to pay for the air carriers. If it is sea mode of transportation, you have no like these container ships. You have no like mini carriers, no like who has container ships like Maersk, MSC, and no like Evergreen. So you have to pay for them. You have to pay for the carriers. So carrier charges are there, and the destination port charges, destination port custom charges, and the destination port labor charges, and the destination place transportation charges, the delivery charges. So there are no like many charges. There is no money is no like heavily involved in the sale of goods. It's not that simple. So there is more responsibility, like for both the parties. That is for the seller as well as the buyer. That is who's going to take responsibility of which payment. So that would be very clearly mentioned in the contract. So this information is necessary not only for the government, but for the port handlers, but for the carriers, for the insurance people who has no like provided insurance for the goods, and as well as for the no like the transportation people. Everyone wants to know who has taken responsibility for which of the activity, because if something risk has happened while transporting the product, so in that case the insurance company would be like compensating the loss. So whichever party has taken the insurance for the product, so the compensation would be paid to the concerned party. If the seller is taking care of the insurance, paid the insurance, the compensation for the loss would be paid to the seller. In case if it is a buyer, the compensation would be paid to the buyer. So second is sale and agreement to sell. Then the third point is essential of contract of sale. That is, two parties should be involved. There should be goods. There should be price has to be clearly mentioned, and the transfer of property has to be mentioned in the documentation. So we have there are many like many documents involved in the sale of a product. You have this invoice. You have this. Custom clearance documentation, invoice, you have this transportation documentation, you have this delivery note. So there are many documents involved. So which clearly mentions the transfer of property, then essential elements of a valid contract. Then sale and hire purchase agreement, sale and barter or exchange. So barter is nothing but the trade, that is the exchange, and sale and bailment. And price here it means some money consideration for the sale of goods, and the earnest, some tangible things as a token. So all these like has to be clearly mentioned in the contract. So under Sales of Goods Act, which was enacted in 1930. So these things, so that should be mentioned in the contract. So that is what the law, that is the act says. Then this Negotiable Instrument Act. So this negotiable instrument means a promissory note, bill of exchange, or check payable either to order or to the bearer. That is, there is a credit purchase or credit sales happen. It's not a cash purchase or a cash sales. So there is a credit purchase or a credit sales. So let us, it means no, the buyer is promising the seller that no, the payment would be done after the receipt of the goods, or even after the receipt of the goods, after like a month's time or 2 months time. So according to the sale of goods contract, the shipment contract, any buyer who has like made a purchase of goods from the seller has to pay and clear the liability within a maximum of 9 months, like from the receipt of the goods. That is what the law says about. So this law is applicable to all the businesses all over the world, irrespective of like the country, irrespective of anything. So if a buyer fails to pay for the goods, like which the buyer has bought, uh, even though it has been mentioned in the contract within 9 months, then like the law can be turned against the buyer. Lawsuit can be filed against the buyer. So it should be freely transferable, title of the holder free from all defects, and like the recovery, know how to make the recovery. So everything has to be clearly mentioned in that contract. And now there are two types. That is negotiable by statute and negotiable by custom or usage. Negotiable by statute is like promissory notes, bill of exchange, and checks. So post-dated checks. So these kind of promissory notes or no post-dated checks can be issued. And when it is negotiable by custom or usage, so bankers draft or pay order or no like hundis and delivery orders and railway receipt for goods or road receipt, lorry receipt for goods. So this can be used. So in either of the way, the all these are like these are proper documents actually, like these are like the complete set of documents which can be like used for the to safeguard the seller from like encountering the loss. So a buyer cannot um, deny the payment for the seller. So after receipt of the goods. So in that case, if the buyer is not denying to make the payment for the to the seller, in that case, with any of these documents, the seller can file a lawsuit against the buyer. Then is Consumer Protection Act. So this act seeks to provide better protection to consumers' rights. So we know, like we are consumers actually, like we consume many things in our day-to-day life to protect the rights of us, like what are all the rights we have. So be protected against the marketing of products which are hazardous to life and property, and be informed about the quality, quantity, purity, standard and price of products against unfair trade practices. Be assured of access to products at competitive prices. Be heard and be assured that the customer's interest will receive due consideration. Seek redressal against unfair trade practices. And usually, like many of the businesses, they give out their, like a website, or they, give their consumers a toll-free number to call back, like if they are facing any difficulties, or if they know, face any unfair trade practices during the sale of the goods, or even after buying the goods and after usage of the goods. So if the consumers feel they are not happy with the product, they can reach out to the company by sending a mail to that customer care's email service, or by sending a WhatsApp message to the customer care number, or making a call to the toll free number. So consumer education. So every consumer has to be educated on the product, which is marketed to the consumer. So clear information about the product, A to Z about the product has to be, it should be, given to the consumer. There is what is in the product. So what is the product made of, and where it is manufactured, or where it was originated, who has manufactured it, who has marketed it. Manufacturing and marketing can be sometimes done by two different business units. Manufacturing can be done by one business unit, and the marketing of those products can be done by another business unit. So in that case, who is the manufacturer and who is the marketing, company or an agency. Then the shelf life of the product, for how long this product can be usable, the shelf life, and how to safely handle the product. What are the precautionary steps to be taken if the product is little little hazardous, or little risky to handle? In that case, how safely the product has to be handled, and what is the usage of the product, what is the product made of actually, whether it's what are all the chemicals which is used for manufacturing of the product, especially in case of food products. So it has to be clearly mentioned. So so this is what educating the consumer is all about. The business is educating the consumer. So in any case, a consumer couldn't be, couldn't find any of these information on the product, what the consumer is using. Then no, the consumer, you and me, we can file a case against that business firm. There is no proper information, proper education about this particular product is not provided in their label, or in the packaging, or on the product seal, whatever it is. So that information is not being given. So the Act provides for establishment of quasi-judicial machinery at district, state, and center level for speedy and simple addressal. So there is no such thing that you have to approach only the consumer court for the special provisions. No, there are many ways to approach law. No, to get your rights. No, to your hands. There is, you can approach any district court or any state court, or no any center level court for this matter. You have this mobile consumer courts also. They are widely available presently. So there are mobile consumer courts. You can even file a consumer case. No, you can file against a business firm through online mode itself. Through online mode, you can file a case. So if you have the proper receipt, or if you have the proper information with you, the proof with you that you have not been educated on a particular product, so you can file a case. Disputes redressal agencies. So consumer disputes redressal forum. So this is for the dispute which the consumer has with the business who has sold the product or service to the consumer. The person who is or has been or is qualified to be a district judge shall be the president. So that president, oversees everything. Two other members of proven track record. That is both of them from the law only. So one of whom shall be woman. And term of office. No, their term of office is no minimum 5 years to maximum 65 years. So, or if they can be no like a maximum 60 till 62 years of age, no, like whichever is earlier, so they can go with it. And jurisdiction to entertain complaints where the value of the products and the compensation, if any, claim do not exceed 5 lakhs. So there is a commission for this consumer disputes redressal, the state commission and the national commission. We have two commissions. When it comes to state commission, which is mentioned under section 16 to 19, a person who is or has been a judge of a high court shall be the president. State government appoints under consultation with CJ of HC, that is no like high court. Term is 57 or 67, that is 5 years in the sense, no, like after the retirement. Don't think that, no, 5 years means, okay, the judge should be, no, like just 5 years. It means after retirement. Sometimes the judges, no, like few district or state level judges, they retire between, no, like 60 to 62 or 65. So after their retirement, sometimes, no, they may have an extended service for another 5 years. So in that case, so term is no like either the 5 years, they can be serving an extra 5 years or a maximum of 67 years of age. So these are the jurisdiction now between no like not more than no 5 lakh, but not more than 20 lakh. That is minimum 5 lakh, more not more than, but not more than 20 lakh. So appeals against the order of the district forum. When it comes to national commission section, no, that is section with this section is mentioned in no 20 to 23. A person who is or been has been a judge of the Supreme Court shall be its president. Central government appoints under consultation of CJ or CJ of the SC. And again, here there is a term of no like 5 years or 70 years of age, whichever is no like earlier. Appeal against National Commission can be done in SC within 30 days. Okay, then we are coming to the MRTP Act. So this term you would have known widely. So MRTP it refers to Monopolies and Restrictive Trade Practices Act. So what is a monopoly? Monopoly is a particular business which completely covers or completely engulfs the market with its products only. That is, there is no competitors for that company. So no, those companies are no like that. Usually they are mentioned as monopolies. They may practice no like any unfair trade practices, or they may no like maybe because of a unique product they may be a monopoly company, or because since the competitors have no guts, or no like they are not confident enough to know to know like have a good competition with this particular company, the competitors may not be entering into the market. For any of these reasons, the monopoly can be the the king of the market. So how to know protect the consumers from those monopolies, and how to protect the consumers against the restrictive trade practices. So this act is all about that. The act aims at preventing concentration of economic power. So if there is a monopoly, it means the complete economic power is no concentrated towards that particular company only. Prohibiting monopolistic trade practices, prohibiting restrictive or unfair trade practices. Constitution of MRTP Commission is, it comes under Section 5 of the Act, and it requires central government to constitute a commission, that is MRTPC Act Management. So this commission will have a chairman and no like a minimum 2 or a maximum 8 members. There is a board. So this board will have a chairman. Other than the chairman, there would be like juries. Juries in the sense they act as a you know what is a jury all about, right? They act as a like helpers to the judge, or no helpers to the chairman. So minimum 2 or maximum 8 members can be of that panel. No, they constitute a panel. So term is 5 years. and they can be reappointed for the second term. Even after the retirement or even after serving for 5 years, they can be reappointed for the second term only. Or that person, the chairman, has to be 65 years of age, whichever is early. So powers of the MRTPC. So powers of a civil court and powers to inquiry and pass a final order. That is the MRTP court. What powers does it have? So, as civil court, like this MRTP court is like it considers a civil court since it deals with the like protection of the consumers. So to inquiry and pass final order, to make inquiry and expression opinion. That is like an inquiry has to be made on the first basis, a complete clear inquiry. So when a consumer is like filing a defamation to suit or like any kind of lawsuit against a company or a business entity, so first and clear inquiry has to be made, and to grant temporary injunction to award compensation. That is getting the compensation on behalf like for the customer from the company. So that also can be done by this MRTB court, and to enforce orders of MRTPC, to investigate whether the orders has or been implemented, to punish for content, and to regulate the procedure. So these are all the like the powers of the MRTP court. So Foreign Exchange Management Act, that is FEMA, was replaced by FERA. FEMA, it represents, it means Foreign Exchange Management Act. FERA means Foreign Exchange Regulatory Act. That was now enacted in 1973. Then FEMA replaced it from 2000. So it is an authorized person and like it has duties like RBI may, on an application made in this regard, authorize a person to deal in Forex. Forex is foreign exchange. So what are the duties? To comply with RBI direction. Any transaction, especially like for us, for like Indians, we have this RBI. In the same way, each and every country will be having like an entity like an RBI, like which takes care of all the transactions, which is happening between like their country and the other country, or between the consumers of their country. So to comply with the RBI direction. So any transaction which is happening within the country, it is within India, or I'm taking an example of India, okay? So within this country, or whatever is going out of this country and not coming into this country. I mean, like the cash, the money or money value. So it like it has to like go, and it has to be like done under RBI only. So no money will like go out of the country or come inside the country, or like between the like the business exchanges without the consent of the RBI. So it's otherwise it's like considered as a criminal offense. To ensure compliance of FEMA, to produce books of accounts, and RBI may issue instructions time to time to help this like foreign exchange management. So RBI, they will issue instructions time to time, because the economy of the world like it keeps on changing. It's not static, it's completely dynamic. So the inflation rate, the money value, so everything like the stock market, share market, everything like everything is dynamic. It keeps on changing every second. So in that case like RBI will be instructed this foreign exchange like the management persons like who are like governed by the RBI, and RBI may inspect the authorized person. So FEMA, so contravention and penalties. So this takes care of the penalties in the enforcement of orders of adjudicating authority, and power to compound contravention. And if it is education and appeal is like you are like appealing to a to the court or to the like to the FEMA. So adjudicating authority, appeal to special director, appeal to appellate tribunal. Tribunal is again a kind of a like a law entity, a court entity. So you can like go for the appeal to tribunal as well. The main difference between a tribunal and an actual court is Tribunal tries to solve the issues, like as quick as possible. Whereas, court, it needs, like it takes some more time. The law actually, like it takes the court and the law, it takes more time to to give a judgment for a particular case. Like there are many proceedings there, but the tribunal tries to dissolve the like the disputes or the issues, the conflicts between two parties then and there. So to make sure, like not many cases are like piled up on in courts. So to avoid that situation, tribunals are being tribunals are helping out. So appellate tribunal. So this is a constitution. Then there will be a chairperson and there will be a team of members. And the term is again 5 years. Whoever is the chairperson, so 5 years after the retirement, and 65 or maximum 65 years of age or 62 years age bar respectively. So powers of tribunal and SD shall not be bound by the code of civil procedure. They will have same powers as or vested in a civil code, almost the same. So whatever civil code, whatever powers a civil code holds, the same power will be, like the tribunal will also be having. Their order shall have some same decree as that of a civil code. There is no such difference. The only difference being tribunal tries to solve the problem, that is negotiates with the parties who are involved in the disputes or in the conflicts, and try to solve the case or the problem then and there, so that it can like avoid these persons like by like going to the court. All proceedings under these shall be deemed to be judicial proceedings. Power to interbench, transfer, and appeal against their decision may be filed in High Court within 60 days of the receipt of such decision. So, as a consumer, or you're not happy or satisfied with the tribunal's decision. So, in that case, so after the tribunal has given out their decision, so after receiving it, within 60 days, you can appeal the decision to the High Court. And finally comes the Information Technology Act. So digital signature, all these is covered in the Information Technology Act. Electronic governance, certifying authorities, appointment of controller and other officers, functions of a controller will be mentioned, controller as repository, license to issue digital signature certificates, application, renewal, suspension of a license. So that will be taken care by the members of the Information Technology Act. Power to delegate and investigate. So that the tribunal, like they the team, that has the power. And it comes to penalties and adjudication, penalty for damage, penalty for failure to furnish information, residuary penalty, and power to adjudicate. Residuary penalty is nothing but uh, you have some issues with the say a network provider or something, and the issue is not being resolved for for many days, for ages it's not being resolved. So in that case, it becomes a residuary penalty. So not only for your loss, but they have to pay for the time they have the more time they have taken to resolve the issue. That is residuary penalty. I think we are almost to the end. So cyber regulations and tribunal, establishment of tribunal, nothing but it's just like information technology. So composition of tribunal shall consist only of one member termed as a presiding officer. And this is all about the qualifications of presiding officer. And civil court not to have jurisdiction or appeal to HC. So this should be noted. So here the civil court will not be having any jurisdiction, and appeal to HC is not possible. So this tribunal, cyber regulations tribunal, so this thing resolves the issues then and there, because everything is evident. So no one can escape in the eyes of cyber. So anyhow they will trace it out. No, from whichever system or from whichever technology you are going to you are using it to commit any kind of offensive or any kind of crime, you will be traced. That is, we will be traced. So there is no such thing called appeal here. If the Cyber Regulations Tribunal decides something, it's done. No, you cannot escape that. So no, then finally the Patents Act. This was enacted in 1957. So patent application can be made by any person claiming to be the true and first inventor of the invention, any person being the assignee of the above person, before any, the legal relationship, the legal representative of any deceased person who immediately before this death was entitled to make such an application. There is no imagine a person who has invented something, but before getting the patent that person dies. In that case, if there no another person is appointed by the person who has died, who has invented, so this person can make an appeal or make an application to get the patent for the deceased person, not for himself. And the examination of applications, exclusive marketing rights will be given to the applicant, and the opposition to grant of patent and working of the patents. So there's no there will be some time period or something, for patents and all. So there's no such thing. There's no this patent will exist for lifelong. You have to keep on renewing few patents. So there will be a working period for that. Then is the Copyright Act, Patent, and then Copyright Act. The government established a copyright office under the control of Registrar of Copyrights. Government has also constituted a copyright board. So, what is the difference between patent and the copyright is? Uh, Copyright is something, there is a copyright is mostly given to the logo of the company, the name of the company, and the colors used in the logo of the company, or the the captions, which is used for the company. So these are the copyright things, or the technology, which is being used in the business. No, so for these things, copyright can be sorted. For the name of the business, copyright can be sorted. Whereas patent is something that without the permission of that person who has got the patent, you cannot use that technology. That is the difference. So the government has also constituted a copyright board. Registrar of Copyrights is the secretary of the board. Board shall be deemed to be a civil court, and the board will have chairman who's or has been a judge of a high court or is a qualified to be a judge of a high court. Copyright subsists in original, literacy, dramatic, musical, and artistic works, cinematograph films, and sound recordings. So, not only this is very limited actually. So, copyrights can be given to almost every type of business units. So, memorandum and articles of association. So, so memorandum, no, what is a memorandum? There is no uh, see, what an association has is being functioning, and they have a set of rules and guidelines to be followed. So these associations, it can be unions or it can be an association for the employees, within one particular company. So it can be any kind of association. So they follow certain guidelines, certain rules to protect these associations. Uh, to make sure these associations function in a a good manner without any discrepancy. So there are laws to protect these associations as well. So there are many things: state in which the registered office of the company is situated, object of the company within the which company shall keep its business, and articles of association or the rules, regulations, and bylaws for the internal management and affairs of a company. So company association, no, within the company, no, there are associations. Distinction between memorandum and articles of association will be clearly mentioned in this act. And the most important thing is reasonably and fairly incidental to its objects. Everything else is ultra vires. And sorry, the purpose of this doctrine is twofold. First one being to protect investors investors in the company, and the second one is to protect creditors to ensure appropriation of funds. So we have come to the end of the session. So we are not like stopping the business law as of now, because no like business law, it's a not like a very extensive subject. No like if you start going on with no like the if you know like go still dig deeper into the business law, you will be no like coming to know more about no many laws no involved in this business context. So I don't want to get too much deeper into the subject, because you will be after some time no like we will be no like discussing about no all the laws no which is no like prevalent. So that won't be necessary. So these are the basic and the few important vital laws, no, like in the business field. Not only in the business field, because all the parties who are involved in the business, you have this monopolies, you have this consumers, you have this patent, you have this copyright, you have this association, trade union law. Everything is interconnected with the business. So that's why, like I have taken only, like these important topics no under this business law module. So from next week we'll be having another new module or new topic for discussion. So if you have any doubts, you can stay back for 2 more minutes. You can ask doubts, or else we will meet next week.